Hello everyone, welcome to Court with Krissy. Time for an update. This guy, he's back. His last appearance, he was sentenced to prison, but the night before that, he was arrested and got new charges. So this is his second sentencing. And say it with me now, folks. Consecutive. You don't hear it very often. As always, I've linked the last appearance in the video as well as in the description. I hope you like it. Court with Krissy is now in session.
Goodman, this is file number 255099. The record should reflect here in the courtroom today. This is the date and time set for sentencing. Mr. Goodman, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Seeger about that?
Yes, Your Honor.
Okay. Mr. Seeger, are there any additions, deletions, or corrections to that report?
No, Your Honor.
And are there any challenges to the scoring of the guidelines?
They're not, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, Mr. Goodman is back again for an RO that he committed the day before he was to be sent to prison by Judge Hunter. During his detention by the police, he told police that he was being sentenced to prison the following day. He knew full well what his circumstances were, that he was on bond for a felony and that he was going to be subject to a prison sentence. Despite all of that, and despite the fact that it was a felony drunk driving, he engaged in assaultive behavior, he was intoxicated, he resisted officers, and he was ingesting, or at least attempting to ingest, pills that the officers had to force him to spit out or stop him from ingesting. The defendant's criminal history is atrocious. The statement in the PSI that he is a moderate to high risk for recidivism is comedic understatement at its finest. With 26 convictions now, repeated violations of bond and PPO conditions throughout his life, Mr. Goodman simply will continue to commit crimes, regardless of court orders or court supervision. Consecutive sentencing is the only way to punish this conduct. Any guideline sentence without a consecutive sentence makes this case meaningless to Mr. Goodman and meaningless to law enforcement who continually have to deal with Mr. Goodman. The entire point of allowing discretionary consecutive sentencing is for cases like this, where the defendant blatantly, flagrantly violates his conditions of bond by continuing to commit crimes, continuing to drink, continuing to resist officers, because he knows there will be no real repercussions for it, as he's already subject to a greater sentence. A consecutive sentence in this case is a matter of both personal and general deterrence. Mr. Goodman and society at large need to understand that you do not get a free bite at assaulting law enforcement simply because you're going to be sentenced soon. The recommendation of a concurrent sentence sends entirely the wrong message, both to Mr. Goodman and to the community, and does not accomplish any of the goals of sentencing. A concurrent sentence does nothing to punish the defendant, nothing to rehabilitate him, and nothing to deter him or society going forward. I would ask the court to sentence the defendant to 12 months consecutive to his current MDOC sentence.
All right, thank you, Mr. Seeger.
Yeah, by way of elocution, I've known Mr. Goodman, unfortunately, for a period of time, and I don't really disagree with Mr. Ziegler in as much as Mr. Goodman has been to court quite a few times, and it always revolves around him being intoxicated because he has a pretty serious alcohol problem. And unfortunately for Mr. Goodman, currently he's lodged with the Department of Correction for a period of 2 years, for which Judge Hunter gave him a sentence. And Mr. Ziegler is correct, there was a problem the night before in advance of being sentenced. But it didn't have specifically to do with law enforcement. He wasn't fighting with law enforcement per se. He got into an argument with a person that was a drinking buddy, and then he subsequently was struggling to follow some pretty basic commands of law enforcement. But be that as it may, Your Honor, he has learned from this. He is incarcerated for a period of time. Our larger question, Your Honor, is whether or not the court runs the matter consecutive or concurrently. It is discretionary. However, I would just ask the court to consider running it concurrent. In review of the pre-sentence investigation report, the recommendation is that the sentence be run concurrent. I also think that it's a difficulty for the jail in as much as it's not entirely clear to me if the court did run things consecutively, presumably he would have to serve his prison sentence first. And then once he's released on parole from the Department of Corrections, he would be returned to Kilkasket County, for which he would be subject to a jail sentence for an extended period of time and whatever amount it is that the court might impose. Because I don't think he can serve his jail sentence first, he would have to serve it second because he's already at the Department of Corrections. So I understand Mr. Ziegler's points and his concerns. As a matter of practice and functionality, I think it best is to run things concurrently. He is at the Department of Corrections. Had all these things happen exactly at the same time, he would still be at the Department of Corrections. It is a burden on the county for him to have to come back and use our resources once he'll be under the thumb of the Department of Corrections once he's paroled. So it would be a burden on the community in as much as we have to pay for his housing costs while he's incarcerated in our local county jail, whether it's Wexford County or Kilkasket County. I see no benefit in giving him additional jail time. I'm not necessarily saying that it would be wholly unwarranted in some situations if he wasn't at the Department of Corrections already for a period of time. Mr. Goodman has expressed to me remorse for what he did. He's also expressed that he needs to get a handle on his drinking. Hopefully while he's incarcerated at the Department of Corrections, he's not consuming alcohol of any kind. I guess I can't say what happens at prison there, but theoretically he's not using drugs or substances that are going to alter his thought process. Presumably he's trying to take care of things that he can address while he's there, classes, things of that nature. There are reentry programs that he'll most likely have to engage in, so hopefully he's able to improve his life. Generally speaking, Mr. Goodman's a decent person. It's just that when he's drinking, he becomes quite belligerent and he struggles to conform his decisions to that of an ordinary person. But he has expressed a want to change. He has expressed a need to make better decisions once he's released. He's just hopeful that the court will consider running things concurrently, in as much as from a practical standpoint, he would have to theoretically probably have to come back to our jail for whatever period of time it is that the court would impose if it did run things consecutively, which again is an onus on our county, as much as we're going to have to pay for his housing fees. Lastly, Your Honor, because he's unable to pay court costs and fines currently because of his incarceration, there are some monies that are withdrawn from his account that go specifically to his court costs and fines for the file for which he was sentenced under Judge Hunter. I think they'll take 50% of whatever is in his account. He was hopeful that the court would not impose any additional court costs or fines to the extent that that's reasonably practical, in as much as he doesn't currently have the ability to pay those court costs and fines. And having never been to prison, Your Honor, I don't know. I'm guessing it's probably not particularly easy to survive in that environment. He has to adapt because he's there for what he did. But the very small amount of money that he's given each month is halved by the amount of court costs and fines through the other file. And he was hopeful that the court would either stack those fines on Judge Hunter's file, or in an alternative, lessen the amount so that he'll at least have some money to somewhat survive while he's incarcerated there.
All right, thank you. Mr. Goodman, anything you wanted to say today?
Yeah, I just want to know, I went down to RNDC, they checked my liver. Yeah, I gotta stop drinking, I'll be dead. So, yeah, I made some bad choices, but I know totally agree, but I'm not trying to argue it, nothing here. Just, the incident with the officers wasn't totally aggressive like Ryan Ziegler says. It was more like, I didn't give him the phone, I didn't give him a pill. He jerked me out of the car because I refused to give him a pill. They already got the phone and they started pressure pointing me that I never swung on him, I never grabbed him or nothing. I just want to let you know that, I remember that. They were there for assault with my friend, but it's all because of drinking. stupid shit. You know, but this is it. I'm tired of going back to prison. This is my third time. I'm 56, getting sick of it. Finally, it takes you getting sick of it before you'll change, you know? Now I have to or I'll die. Well, that's what I'm saying. Thank you.
All right. Mr. Goodman, I did read through the report, so I'm familiar with what happened in this case. And also in that report was the report from Judge Hunter's case, which I'm not basing the sentence on that information, but that gave me some more background. And then there's a lot of background in that report about you generally and your circumstances, your past history. I think we can all acknowledge that, you know, your prior convictions are numerous and go all the way through your entire adult life. Been on probation 8 times, you've had 10 prior jail sentences, and as you indicated, 2 prior prison sentences. So you're currently serving your 3rd prison term. You know, and so when the court is looking at what is an appropriate sentence here in light of all the goals of sentencing, which includes rehabilitation, at this point with the number of convictions that you've had and your age, the court stops focusing so much on rehabilitation because again, with 8 prior probations, 10 prior jail sentences, over a period of time, it starts to become apparent that court intervention isn't causing anything to change. Maybe your health and maybe your age for you personally will cause you to look at things differently. But in terms of what the court's willing to commit in terms of community resources towards rehabilitation, we're really getting towards the end of that. What we're looking at now is punishment and deterrence to keep you out of circulation, to keep you out of the community where you can't drink and cause harm to others, put other people in danger. And, you know, given the circumstances here, it looks to me like this is your classic kind of thing where I know I'm going to prison, so I might as well go out with a bang. And that's why the court has the ability to sentence discretionary consecutive, because if it appears that that's the circumstance, then that gives people kind of a free pass if they know they're going to prison to commit more crimes and then hope that everything just gets rolled up into one and served concurrently. And where that's the case, the court can impose a consecutive sanction so that it isn't a free pass and you have to pay the price for that additional criminal behavior. And it's apparent to me, based on what I read in the report, that that's what happened here. And so for that reason, I do think a consecutive sanction is appropriate. Because of your behavior, knowing that you're going to prison, your statements, well, just take me to jail because I know I'm going to prison, and your actions here in assaulting another individual and resisting or obstructing police the day before you know you're going to be sentenced, all of that to me is more than adequate, at the very least, circumstantial evidence that your mindset was, I'm going to do what I'm going to do. It doesn't matter because I'm going to prison. And so I think for those reasons, again, I think
As long as I was drinking, sober, I wouldn't say crap like that, you know?
Sure, but you weren't sober and you didn't do that. So there's a penalty to be paid for that. And I think it's appropriate on those, based on those circumstances and based on your just entire past history, which indicates to me that if you're out, you're going to be abusing substances and causing problems. And you can argue to me all you want.
I'm just saying, put it on time control, you don't like to just run around and do what you think I'm doing.
Yeah, well,
Keep it in control.
you've been on probation 8 prior times, jail 10 prior times, 2 prior prisons, which means you've been on parole twice. None of that's worked. So why should I think it's going to work this time? Right? So I'm not going to bet on that. And I think discretionary consecutive is absolutely appropriate in this circumstance. The guidelines in this case are 2 to 17. I think the maximum sentence is appropriate here for the reasons I've stated, in addition to the consecutive sentencing sanctions. And the court can go up to 16 months under the 10 or 2/3 rule. So the court is going to sentence you here to 16 to 24 months in the Michigan Department of Corrections. The court is going to order that that sentence be served consecutive to your current prison sentence. You are entitled to 2 days of credit. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. That's going to be in addition to your prior case. Again, for the reasons I've stated, I see no reason why there should be any leniency here from a financial standpoint either. So that is a sentence of the court. You do have the ability to seek an appeal of this sentence. We're going to provide you with some papers that explain to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with that. Mr. Seeger, if you just let me know once Mr. Goodman's acknowledged receipt of this appellate right.
You would acknowledge receipt of this appellate rights, giving him a copy of the same.
All right, thank you. Good. Investigate the stage this time.
It's been
Take a short recess until 10:30.